Welcome to America Narratives. In a heavily guarded vault at the National Archives in Washington, D.C., preserved in an argon-filled case, lie 4 pages of parchment. Every year, over 1 million people file past in quiet reverence, gazing upon the original copy of the United States Constitution. It is treated as a sacred text, the nation's civil scripture. Yet, beyond these quiet halls, the words on this document are the ammunition for America's loudest, most bitter, and most consequential battles. How can a text written by candlelight in the 18th century dictate the rules for a 21st century digital society? How can the same sentences be used to justify entirely opposite outcomes on issues from gun control to privacy? The answer lies not just in what the Constitution says, but in a profound and often irreconcilable war over how it should be read. This is not merely a legal debate. It is the story of 2 Americas, each fighting for the soul of the nation, using the same rulebook. This is the unfinished Constitution, America's battle for its own rules. To understand today's battles, we must first travel back to their origin. The year is 1787. The victory of the American Revolution feels hollow. The new nation, governed by the weak and ineffective Articles of Confederation, is falling apart. States are printing their own money, engaging in trade wars, and a farmers' rebellion in Massachusetts has shaken the elite to their core. It is in this atmosphere of crisis that 55 delegates gather in Philadelphia, not with a unified vision, but with a desperate, pragmatic goal: to save the Republic from itself. The men who gathered in that sweltering summer were not demigods who agreed on a single, divine philosophy. They were practical, often deeply divided politicians. They argued fiercely. James Madison, the architect, battled with those who feared a strong central government. Delegates from large states clashed with those from small states, and most ominously, the convention was haunted by the institution of slavery, forcing convoluted and morally bankrupt compromises that would defer a bloody reckoning for another 70 years. The document they produced was not a perfect treatise of ideals, but a bundle of tense, hard-won compromises. It was designed to be a starting point, a framework, not a final, unchangeable answer to all future questions. The founders themselves knew this. They included a process for amending it. They understood the conversation was just beginning. It was, from its very inception, an unfinished document. For much of American history, the interpretation of the Constitution was a matter for lawyers and academics. But in the 20th century, as the Supreme Court's power grew, this arcane debate erupted into a central conflict of American public life. Today, that conflict is defined by 2 warring camps, 2 fundamentally different ways of seeing the document and the nation itself. On one side stands Originalism. At its core, Originalism is the belief that the Constitution should be interpreted based on the meaning it had at the time it was written. Originalists argue that this is the only way to ensure neutral, objective justice. They believe a judge's job is not to impose their own modern values, but to act as a neutral referee, applying the rules as they were originally understood. To do otherwise, they argue, is to allow judges to become unelected, black-robed legislators, twisting the law to fit their personal political preferences. This philosophy champions judicial restraint and democratic principles, arguing that if the Constitution is to be changed, it must be done by the people through the difficult process of amendment, not by the whims of 9 justices. On the other side is the philosophy of the living Constitution. Its proponents argued that the Constitution was never meant to be a static relic, frozen in the 18th century. Instead, they see it as a living document with core principles of liberty and justice that must be adapted to the realities of an ever-changing society. They ask, how could the founders, men who owned slaves and did not see women as political equals, have conceived of the challenges of the modern world? Could their understanding of speech have possibly included the internet? Could their understanding of searches and seizures have anticipated digital surveillance? To adhere rigidly to their 18th century mindset, proponents argue, would be to render the Constitution obsolete and to betray its own promise of creating a more perfect union. A living Constitution allows the nation to grow, to correct past injustices, and to apply its foundational values to new and unforeseen challenges. This is not an abstract philosophical debate. This intellectual war has profound, real-world consequences, shaping the lives of every American. Let us examine the modern battlegrounds. Perhaps no battleground is more explosive than the Second Amendment. Its 27 words are a source of endless debate. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. For decades, courts interpreted this through the lens of the opening clause, linking the right to bear arms with service in a state militia. But originalist scholars began to argue that the 18th century public understood the phrase, the right of the people, as an individual right, separate from militia service. This culminated in the landmark 2008 Supreme Court case, District of Columbia versus Heller. In a 5-4 decision authored by the leading originalist, Justice Antonin Scalia, the court declared for the first time that the Second Amendment protects an individual's right to possess a firearm for self-defense in the home. It was a monumental victory for originalism. Proponents of a living constitution, however, were aghast. They argued that whatever the founders' intent regarding muskets, applying that same logic to modern, high-powered, semi-automatic weapons in an urban society was a dangerous absurdity. The battle rages on. Consider the First Amendment's guarantee of freedom of speech. In the 18th century, this meant the right to speak, publish pamphlets, and criticize the government without being thrown in jail. But what does it mean today? Does it mean corporations have the same speech rights as people, allowing them to spend unlimited money in political campaigns, as the court ruled in Citizens United? Does it protect hate speech or deliberate disinformation that can be amplified to millions in an instant on social media? An originalist might argue that the founders' principle of protecting all political speech, even odious speech, must be upheld. A living constitutionalist might counter that the founders could never have foreseen a media ecosystem where bad faith actors could use that freedom to undermine the very foundations of democracy itself. The most powerful engine for change has been the 14th Amendment. Ratified after the Civil War, its clauses guaranteeing equal protection and due process of the law were intended to protect the rights of newly freed slaves. For a living constitutionalist, these clauses are a wellspring of evolving liberty. They were the basis for Brown versus Board of Education, which outlawed racial segregation in schools, overturning the original understanding of the amendment's authors. They were the basis for landmark privacy rights, and more recently, for Obergefell versus Hodges, which guaranteed the right to same-sex marriage. For proponents, this is the genius of the living Constitution in action, applying a broad principle of equality to right a wrong that the founders never addressed. For originalists, these rulings are prime examples of judicial overreach, of judges finding rights in the Constitution that simply are not there, and in doing so, stealing power from the democratic process. And who is the ultimate referee in this unending battle? The Supreme Court, a body of 9 unelected individuals who serve for life. The founders did not envision the court having the immense power it wields today. Its role as the final arbiter of the Constitution's meaning was established by the court itself in the 1803 case of Marbury versus Madison. Today, the political battles over Supreme Court nominations are so vicious precisely because everyone understands the stakes. A single appointment can shift the court's ideological balance, changing the dominant interpretive philosophy and therefore changing the meaning of American law for a generation. The fight for the court is the proxy war for the Constitution itself. So, we return to the vault in the National Archives, to the revered document in its gas-filled case. Its survival is a testament to its brilliant design, a framework flexible enough to govern a nation through civil war, industrial revolution, and the digital age. But its power comes not from its permanence, but from its perpetual state of being unfinished. The conflict between originalism and the living Constitution is not a flaw in the system. It is the system itself working as intended. It is the mechanism by which each generation is forced to argue, to debate, and to define for itself what it means to be an American, what it means to strive for that more perfect union. The Constitution is not just a rulebook handed down from the past. It is an ongoing, often messy, and profoundly important national conversation. And the most important words are not hidden in its complex clauses, but stated plainly in its opening line, "We the people." It is the people who, through their engagement, their debates, and their votes ultimately give this unfinished Constitution its enduring life and meaning. What is your interpretation of the Constitution? Should it be a fixed anchor to the past, or a living document that evolves with the times? Share your thoughts in the comments below. This is a conversation for every citizen. If this analysis provided you with a deeper understanding, please consider liking this video and subscribing to America Narratives for more documentaries that explore the foundational issues shaping our world. Thank you for watching.